American History Survey courses, I make the focus of my classes the U.S. Constitution. I try and tie as many events and circumstances as I can back to the U.S. Constitution. And I put together a series of lectures looking at the points in the Constitution. One of them we're going to have tonight about religion in the Constitution. If I can, maybe I can just... Today is religion in the Constitution. There are 3 references to religion in the United States Constitution, and we're going to take a look at the 3 of them. But religion, as one of our speakers there mentioned, is extremely important to Americans. It is an extremely personal thing to many Americans, but we need to figure out a way to incorporate religion in with the law, and the founders thought about that because they are not separate as many people even in history would assume or think. We're going to take a look at a number of Supreme Court cases that are going to try and figure out what the meaning of religion and the Constitution actually is. Some of them are not very favorable to many people in the United States, and some of them have come in favor with people in the United States. And we'll kind of walk through a handful of cases to see the development of religion over the course of American history. There are roughly 350,000 mosques, synagogues, churches, and temples in the United States, and roughly 68% of the people in the United States belong to one of those 4 institutions. 9 out of 10 people in the United States, according to recent surveys, believe that there is a God. So religion, as I said, is a very personal thing. Religion is one of the most referenced aspects of the Constitution outside of the military. The founders did spend plenty of time talking about religion in the Constitution. And let's take a look at a couple of those references. The first reference that we see to religion in the Constitution is in Article 6 of the Constitution. No religious test shall ever be required as a qualification to any office or public trust under the United States. The second time we see religion is in the oath of office. I do solemnly swear. It's kind of a veiled reference, but to swear on something, at least in the time of the founders, was that you were swearing into something larger than yourself, a being larger than yourself. You're taking an oath to that person, and how that being, and how do we know that? Because they put the word "or" affirm. Even if you don't believe in God, you could hold the office of the presidency according to the founders. 4 words that we do not see there in the oath. Anybody know where they are?
Yes. So help me God.
So help me God, right? So help me God is not listed in the oath as it is written in Article 2 of the Constitution, but it has become a tradition that every single president that has taken the oath of office has said those 4 words. Every single president, George Washington, started this tradition, and every single administration of the oath since George Washington first took the oath in downtown New York has uttered those 4 words at the end of their recitation of the oath of office. The next time we're going to see religion, and the last time we're going to see religion actually articulated in the U.S. Constitution, is in the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. This is the one that we're going to spend some time talking about. The 2 parts of the First Amendment. The Establishment Clause of the First Amendment and the Free Exercise Clause of the First Amendment. It may mean something different than the words actually are, because the Supreme Court has interpreted them in different ways over time. If you take a look here with something that is unique, something that most people don't know about the Bill of Rights, as it's originally written and ratified in 1791, and as it is interpreted by the Supreme Court initially, it does not apply to the states or local government. It only applies to the federal government passing laws regulating religion or prohibiting the free exercise thereof. How do we know that? Because it says Congress shall make no law. It doesn't say Congress and the states shall make no law. What happens is the 14th Amendment is ratified in 1868, and that is going to begin the incorporation of the First Amendment and the Second and many of the other amendments in the Bill of Rights to apply to the states as well. That incorporation process, incorporating the first 8 amendments to also apply to the states, takes over 100 years, and we are still doing that. The 7th Amendment, which incorporates, which deals with civil lawsuits, does not apply to the states. It only applies to the federal government. It has not been incorporated. But before we get too into the incorporation idea, let's take a look at a handful of cases. The first case we're going to take a look at is called Reynolds versus the United States in 1879. In the mid-1870s, Congress begins passing a series of laws targeting the Mormon faith. prohibiting them from owning property, seizing property in some cases. So Mormons, realizing this, begin to move out west to escape some of the persecution. They escape out to the territories where the laws actually still apply, because Congress is entrusted in the Constitution with regulating the territories. A man named George Reynolds is going to sue the government under the idea that the government has banned polygamy. He's married to 2 women. He's actually charged with a crime. Polygamy is actually punishable by up to $500 fine or up to 5 years in prison. And George Reynolds is actually charged with the crime of polygamy. He's going to sue on the grounds that the government is violating his First Amendment right to free exercise. The first clause we're going to look at that is the second one, actually, and that's the free exercise clause. The government, he's going to argue, or his lawyers are going to argue, are interfering with the way that he practices his religion. Part of the Mormon faith, it was not only allowed to marry more than one wife, it was the duty to marry more than one wife. Believing that the more you have more than one wife, you could procreate more than 1 or 2 or 3 children, and they could carry on the Mormon faith, and you would have this population growth that would also follow the Mormon faith. George Reynolds is going to sue on the grounds that, again, this is a violation of his free exercise clause of the First Amendment. Now, the Supreme Court for the first time is going to rule on what the First Amendment free exercise clause actually means. They're going to say Congress was deprived of all legislative power over mere opinion, but was left free to decide actions which were in violation of the common good. So they cannot regulate what you believe, but they can regulate the way you practice your faith, according to the Reynolds versus United States. Morrison Wade, the Chief Justice at the time, writing in the 1870s in this opinion. So we're going to see how this plays out in other cases. What they also say, something that's interesting, is that the word religion is not defined in the Constitution. Although we see a number of references, as we pointed out, to religion in the U.S. Constitution, they never say what religion is. So essentially, they left it up to the individual to believe what they wanted about their own religion, but the government could regulate the way they practice their faith. And we're going to see how this comes about in other cases in the 20th century. So we must go elsewhere to ascertain its meaning. We must go outside of the law to ascertain what religion actually means. We must go to personal belief. We must go to beliefs of our own church or our synagogue or a mosque or whatever faith we believe, according to this opinion in the Constitution. Now, let's take a look at another case that comes up in 1940. For the first time in 1940, almost 80 years after the 14th Amendment is passed, we're going to see the application of the 14th Amendment to a state. A man named Newton Cantwell and his sons are distributing literature in New London, Connecticut, and it's a mostly Catholic neighborhood, and they're distributing literature. They're members of the Jehovah's Witness faith, and they're going to be distributing literature, and in that literature, it's going to basically condemn the Catholic faith, saying that Jesus Christ, part of the Mormon belief is, part of the Witness faith is the belief that Jesus Christ was not a deity, and the fact that the Witness faith has some problem with the fact of the Holy Trinity. So within this literature, there's going to be criticism of the Catholic faith. People within the town have a problem with this, and there happens to be a law prohibiting the distribution of literature in the state of Connecticut without prior approval from the Secretary of the State, who would have to approve whether or not the literature was religiously affiliated or not. Now, the Cantwell family are going to sue based upon the idea that this is a violation of their free exercise, the fact that how can the Jehovah's Witness faith carry on? This is the way that they solicit people into their faith. So if there's a prohibition of this type of door-to-door solicitation, it could stop membership into their group. So this is a prohibition of their free exercise. This is going to go to the Supreme Court, and they're going to look at it, something called the valid secular policy test. They're basically going to weigh whether or not the law in Connecticut, whether there was a valid secular policy to it. And they're going to say, yes, there is, to prohibit fraud. People coming door to door selling products that are not regulated in any way. In this particular case, they're going to say, this doesn't live up to the test. There is a valid secular policy, but it's targeting one particular faith. And what they say is to condition the solicitation of aid for the perpetuation of religious views or systems upon a license and here's the key, the grant of which rests in the exercise of a determination by state authority. Because the particular religion had to go to the Secretary of the State of Connecticut to get permission whether or not they thought it was a valid religious belief or not, that approval from a government agency or a government person is going to, a government officer, is a violation of the Free Exercise Clause of the First Amendment. That is a forbidden burden to place upon a religion, to have to prove to a government figure that they actually are a religion. So Cantwell is going to be extremely important because it is going to be the first case involving the free exercise clause of the First Amendment with the state action. As we go, the next part is going to be Minersville School District versus Gobitis. Actually, this is actually a typo by the clerk of the Supreme Court. The actual spelling of the name is Gobitas, but because the clerk misspelled it, it goes down in history with the misspelling of the name. The Minersville School District versus Gobitis involves the mandatory resuscitation of the Pledge of Allegiance in schools in the state of West Virginia. Now, they're going to have it where they have to say the Pledge of Allegiance. It is mandatory. They are not the only state to have this. Prior to the 1930s, only 5 states have this mandatory Pledge of Allegiance. As we build up, getting closer and closer to World War II, as things get worse and worse in Europe, other states are going to begin to adopt this as well. By 1840, 18 states are actually going to have this mandatory Pledge of Allegiance. And actually, the kids in this picture are actually pledging the way that they did pledge to the flag in many cases prior to World War II, and that was the one-armed extended salute. This has changed after World War II for obvious reasons. Witnesses, a family of, again, Jehovah's Witnesses are going to counter this. The Gobitis family are Jehovah's Witnesses. Lillian Gobitis, who is 12 years old, as well as her younger brother, are actually going to say that part of their faith requires that they do not show any worship to inanimate objects. And the flag, while a symbol of patriotism, they argue, is a worship. Saluting the flag is a worship to an inanimate object. So they're going to say that this violates their faith. The Supreme Court will weigh in. And again, is there a valid secular policy here? They're going to apply a valid secular policy test. And essentially it becomes patriotism versus religious belief. What do they actually say? In this case, they say patriotism outweighs your religious belief. In 1940, we're gearing up for war. We are in some ways involved with Lend-Lease programs and getting more and more closer and closer to being involved in the war. So they say that there is an obligation, or there is some kind of secular or non-religious advantage to having the Pledge of Allegiance, and that is indoctrinating children to have some faith in our government and to have some belief in our government in a way that they might not have without the daily resuscitation of the pledge. Now, the Supreme Court will very quickly revisit this. Very often, very infrequent that the Supreme Court will overturn itself. They do it very quickly. They do it in just 3 years. In West Virginia State Board of Education versus Barnett, again, Jehovah's Witnesses again are going to sue on the same belief process. What they actually say in this case, though, the American Bar Association as well as other groups are going to say that children that are of the witness faith have been targeted. Newspaper articles will be coming out, editorials will be coming out saying because of the Gobitis decision, children are getting beaten up in schools because they don't want to salute the flag or recite the pledge. And the Supreme Court will revisit itself in 1943, essentially saying that they, resuscitation of the pledge, not saying the pledge is not necessarily a religious issue, but a free speech issue. So they kind of change their mind, but change their reasoning behind changing their mind. They take it out of the realm of a religious belief, and they put it in the realm of free speech. In this case, freedom of speech to not exercise the Pledge of Allegiance. As we go forward, we see a case called Employment Division, Department of Human Resources of Oregon versus Smith. This one you're going to really enjoy. Alfred Smith is a counselor at a drug and alcohol clinic in the state of Oregon. It is a private drug and alcohol clinic in the state of Oregon, and he fails a drug test. He fails the drug test, and they fired him. Is this the problem right here? The problem here is that they fired him, and he's going to use the argument that he's a Native American and he's using peyote. Peyote is a controlled substance in the state of Oregon. It's derived from a cactus plant, and he's going to argue, as part of my faith, for different observances, weddings, birthdays, this is part of our ritual of our faith. Now, if that was the only part of the case, he would have no argument in the Supreme Court, because it's a private company, not government taking action against him. If it's a private individual, it's not the Bill of Rights. The Bill of Rights involves government taking action against us. So in this particular case, because it's a private institution firing him, the drug and an alcohol rehab center, we're not yet up to the Bill of Rights. What happens is, Alfred Smith is going to apply for unemployment benefits in the state of Oregon. Oregon has a clause in their unemployment benefits that if you're fired for misconduct, you do not qualify for unemployment benefits, and they're going to exercise it in this case. Smith will sue the Employment Division of the Department of Human Resources of the state of Oregon based upon the idea that essentially they're punishing him for the free exercise of his faith in smoking the peyote. And what we're going to see here is this is going to go before the Supreme Court. The Supreme Court will make a couple of points that are extremely important. Okay, they will say peyote is deemed a controlled substance by Oregon law. This is what we talked about already. Alfred Smith is fired by private drug and alcohol clinic after testing positive for use. He's denied unemployment benefits from Oregon. We went over this. What will the Supreme Court say? The Supreme Court will say that there's no contention that Oregon's drug law represents an attempt to regulate religious beliefs. So if we get down to what the court is actually saying here, is they're saying, look, this drug law was not targeting Mr. Smith's faith. Essentially, it was this generic anti-drug policy in the state, and it just happened to affect his religious beliefs. Remember, there's no definition of religion in the Constitution, so Mr. Smith can come out and say, well, I am a faith of one person, and it's my faith that I could smoke marijuana 7 days a week. And essentially, if he would have won this case, he could, anybody being charged with any drug crime, could have said, this is part of my personal religious belief. So essentially, this comes down to the valid secular policy test. The valid secular policy, having nothing to do with religion, is that Oregon passes anti-drug laws. And in the enforcement of the anti-drug laws, if it happens to interfere with your faith, they're not targeting your faith. Now, the next case is going to look at the same thing, but in a different twist. The Church of Lukumi Babalui versus City of Hialeah. No, don't ask me to say that again. In 1993 is going to visit the same issue. The issue in this particular case, the city of Hialeah, Florida, is going to bar sacrifice by whoever in private or public ceremony, except for the primary purpose of food consumption. What are they banning the sacrifice of? Animals. What had happened was there were many people living there practicing the Santeria faith. The Santeria faith is a mix of Caribbean, African religions, and part of their rituals for similar to the Native American practice that we see under the Smith case. For birthdays and for weddings and things like that, part of the ritual is to sacrifice an animal for the birth of a child. And what they're going to do essentially here is they're going to ban this particular practice. What do they say? The Supreme Court will actually weigh in. If we use the other test, if we use the test under the Smith case or the Employment Division case, well, this law should stand. There's a valid secular policy here, and that's you don't want to have your neighbors carving up animals in their backyards while you're trying to have a barbecue. Obviously, they say except for food consumption, so the barbecue is fine. But in this particular, that was a joke. So in this particular case, what we're talking about is if it was the exact same case, we wouldn't be talking about it. So in this Church of Lukumi Babalui case, what we see is the Supreme Court's going to say something different. They're going to say, upon even slight suspicion that proposals for state intervention stem from an animosity to religion or distrust of its practices, all officials must pause to remember their own high duty to the Constitution and to the rights it secures. What they actually do in this case is they look at the transcripts of the town hall meetings in the city to figure out what the purpose behind this law actually was. And many of the reasoning behind the city officials was the fact that they were targeting this one specific religion, but in the text of the law, they didn't target the religion. They say whoever does this, not just the people of this faith. So according to the Constitution, according to the court, what they tried to do is they tried to say, look, we're trying to apply this to everybody, but underneath the surface, it really only applies to this one faith. So the Supreme Court kind of catches them red-handed, and they say, look, even the slight suspicion that we are targeting one religion is going to call for increased scrutiny from the court or from any court. Legislators may not devise mechanisms, overt or disguised, designed to persecute or oppress a religion or its practices. So that's what we're going to see there in terms of, these are just a handful of cases looking at the free exercise clause of the First Amendment. The other part of the First Amendment involves the establishment clause of the First Amendment, or the establishment of religion. The first case we're going to take, it's not there. The first case, don't worry about this. The first case we're going to take a look at is a case called Everson versus the Board of Education in 1947. Everson involves a case, a man named Arch Everson is going to sue the Ewing Board of Education in New Jersey on the grounds that they had instituted a program in the state of New Jersey that is going to make it mandatory that local school districts supply all children requiring transportation to public or private schools with busing. Arch Everson is part of this a New Jersey anti-tax group, is going to sue saying, why should I pay a taxpayer for someone to go to a religious institution? That's a violation of the Establishment Clause of the First Amendment, and he's going to make a pretty good case. The Supreme Court is going to hear this case, and they're going to take a look at it, and they're going to say, the Establishment of Religion Clause of the First Amendment means at least this: neither a state nor the federal government can set up a church. There's the first interpretation of what the establishment of religion actually means in the First Amendment. Then we're going to see another one. Neither can pass laws which aid one religion, aid all religions, or prefer religion over another. There's the second interpretation of the Establishment Clause. So the federal government can't establish its own church, neither can the states. Anybody know where this had been done? England, right? England, we still have the Church of England, right? The Church of England, they had escaped persecution in many cases and come to the United States to escape the establishment of a religion that the government's going to tell them what to do. Neither can they pass laws. So now they're saying also in the second part that the Establishment Clause also meant the aiding of one religion over another. And then he's going to pick up on the third one. The clause against establishment of religion by law was intended to erect a wall of separation between church and state. There's the third clause. There are three parts here saying we cannot establish a religion, we cannot aid a religion, and that church and state should be separated. By the way, those are Thomas Jefferson's words in a letter to the Danbury ministers in 1803, saying that we should have a wall of separation between church and state. We'll revisit that in a minute. But they go further in this case. They essentially say in this case we don't have either of these things being done. There were two interpretations that the court could have had. They could have said that this is an aid to a religious institution, or it could be the government providing a service which incidentally helps out a religious institution. The First Amendment requires the state to be neutral in its relations with groups of religious believers and non-believers. It does not require the state to be their adversary. In this particular case, they're saying, look, all other children around the state that go to public schools get busing. So we're essentially punishing children and their families for going to religious schools by not providing them with busing. Now there's another clause that they actually say in here, the state contributes no money to the schools, it does not support them. Its legislation does no more than provide a general program to help parents get their children, regardless of their religion, safely and expeditiously to and from accredited schools. Now what does this mean? In the case they actually make a really good point saying, can you imagine if children are going to a school and they needed police assistance? The police are there to provide them with a safe environment. Could we provide them with police services en route to their religious institution? And they say, essentially, Justice Hugo Black is going to say in this case, in the majority opinion, that in the same way that we would provide police service or ambulance service to children en route to a school, we are providing them with safe transportation to the school. They'll revisit this issue again in 1968 with the case of Board of Education versus Allen. They say, oh, we're providing them with textbooks. We should also provide them, we're providing them with transportation. We should also provide them with what? Textbooks. In 1968, they say that textbooks should also be provided by local school boards to children going to religious institutions. The idea here is that while it may appear that there is a religious institution benefit, the real benefit is going to the child. Now they take that religious interpretation there and they're going to the establishment interpretation, and they're going to take it even further. In these two cases, Winmar versus Vincent, 1981, and Rosenberg versus Rector and Visitors of the University of Virginia, 1995, we're going to take it to the next step. So we can provide transportation, we can provide textbooks. What about providing facilities? The University of Missouri denied use of facilities on school grounds to any religious group. They thought that a University of Missouri, which is a state institution, providing a forum for religious groups was a violation of the Establishment Clause. The Supreme Court will visit that. In this case, in the University of Virginia, denied funding to any group engaged in religious activity. So now you have groups on the campus that are engaged in some type of religious activity. In both of these cases, just like in Board of Education versus Allen, and just like Everson, they are going to say that the schools have to provide assistance to these groups as well. But they do the same thing that they do in the Burnett case with the flag salute. They said that these are free speech issues, not religious issues. You have to give these people, you cannot deny them the right to free speech simply because their message involves some religious connotation. So in these two cases, they're going to go with free speech and not necessarily freedom of religion. The next case we're going to talk about, we're going to extend it even further, this idea of funding. In Everson, we talked about transportation, Board of Education, we have textbooks. In the other two cases, we have providing facilities and providing funding to groups involved in religious activities. In this one, we're going to talk about something that is extremely controversial even today. In Zellman versus, anybody ever heard this case? Zellman versus Simmons-Harris? In Zellman versus Simmons-Harris involves a project in the state of Ohio. The Cleveland School District is one of the most underperforming school districts in the state. Less than 18% of the people in 3rd to 5th grade actually pass proficiency tests. 2/3 of the students, when they reach appropriate age to graduate from high school, do not graduate. This is an extremely underperforming school district. So the state institutes a pilot program saying that any parents want to take their kids and move them out into affiliated schools with the program, they will get a $2,500 voucher. This is a means test saying that we will give you a credit to send your students to a school. 86% of the schools that apply for this program are religiously affiliated schools. Out of the students that participate and qualify, they have to be under a certain income for the family. Out of the students that actually qualify, 96.8% of the ones that qualify and do take part in the program choose to go to a religiously affiliated school. Simmons-Harris is a mother of one of the children that stayed in the local school district, and she's going to sue the administrator of the program in the state of Ohio, Mrs. Zellman. In this particular case, she's going to make the case that this is a violation of the Establishment Clause of the First Amendment, which essentially says that it's encouraging students with a $2,500 credit to go to a religiously affiliated school. Now, in this particular case, obviously they have to find the religious angle in order to get it into the Supreme Court. What else might be at issue here? What do you think? Besides just the fact that, well, if you're a parent living in the school district and your student stands a 66% chance of not graduating college, why might you want to send your student to a religiously affiliated school? What do you think they're doing there that they're not doing in the Cleveland public school districts?
Better education. Better education.
Okay. What else? They're wrapping their knuckles?
Educating.
They're educating them, right? And I know in many of the local public schools around the Cleveland School District, they have a 97 to 98% graduation rate. Why? Because the parents are spending $7,000 to $10,000 per year, per school year, to send their children there. With a $2,500 credit, this might encourage some of them to go there. But what else is at issue here is the fact that if you have an underperforming school district and parents have the opportunity to send their children elsewhere, they may take advantage of it. And many of them do. What does that do to local funding in the local school? Well, that's the art of competition, right? In this particular case, Simmons-Harris is going to also argue that the tax base of the local school is being evaporated. Well, the argument would be made also, well, if your teachers were educating the students, they wouldn't be fleeing the school district. If you had a performing school district, many students wouldn't leave. They would stay there. So in this particular case, you have the religious aspect, but you also have the side issues of teachers trying to protect their jobs and superintendents trying to protect their jobs as well. In this particular case, the Supreme Court in a 5-4 decision in 2002 says that the program does have a valid secular purpose. And what is that valid secular purpose? Educating the kids, exactly. Of providing educational assistance to poor children in a demonstratively failing public school system. In the Board of Education versus Allen and in the Everson case, they can make the case, hey, yeah, we're driving the kids to the door, but once they're at the door, they're on their own. In the textbook case, Board of Education versus Allen, they get every textbook, science, math, social studies, except which one? The one involving religion, absolutely. Any of you in here that may have had children that went to, instead of a local public school, that went to a private school, you go to Umpqua and you pick up your books, and they give you every book except which one? Except the Bible or the religiously affiliated textbook. The first day you get to Holy Trinity High School, they hand that to you. Believe me, I know. Same thing with driving to the local school district. The Massapequa School District, if you live here, has to get you to the door of the school, according to the Everson case. They have to provide you with safe transportation. Why? First of all, because you are a taxpayer here, and just because you're not using the other services in the town, they do have to provide you with some services. The other reason, because the local school district has the obligation of providing you with safe transportation. Now, when they got you to the door of the school, if the bus driver, who is paid for out of the Massapequa school budget by the Massapequa School District, held your hand, walked you to the chapel in the center of the school, told you to kneel down and pray before you start your day, then we might have some type of religious conflict here. But according to the Supreme Court, the fact that they got you to the door, what happened to you beyond that door in terms of religious education had nothing to do with the state whatsoever. Same thing with Zellman versus Simmons-Harris. But we're seeing it extended. Now we're seeing it extended to religious education. But so this is going to become extremely controversial from 2002 going forward. The idea that first we were just talking about transportation and books, then we're talking about spaces and after-school activities, then we're talking about funding of after-school programs, now we're talking about the actual education itself would get a credit from the government, from taxpayers, essentially. Ohio gets around this pretty cleverly. What do? They take the voucher, or they take the credit, or they take the scholarship, and instead of giving it directly to the school, they give it to the parent. This way the parent gets to decide where the credit goes, not the government. So in that way, they kind of get around the idea that the government is funding religious education. They say, no, we're giving money back to a taxpayer, and the taxpayer is deciding where they're going to bring that money. This also brings in the principles of private choice, the idea that the person, once they get the credit, will essentially be deciding where the money will go. Another case we have is Engel versus Vitale, not controversial at all. This involves school prayer. I'm just getting very controversial. 1962, the Supreme Court will weigh in on a New York State law that will essentially be looking at school prayer. In New York State, they had passed a law at the Board of Regents in 1951 stating that the school day will begin with a mandatory prayer. The prayer was mandatory that the school read the prayer, but it was a voluntary prayer. If you wanted to recite it, if you wanted to be part of it, that was your option. If you wanted to walk out of the room, that was your option. And it was a non-denominational prayer. What does that mean? Well, here's what the prayer actually was. Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country. Amen. Now, when I talk to 18-year-olds about a non-denominational prayer, they say, well, that mentions God. I say, yes, but it doesn't say Almighty God and baby Jesus. We acknowledge upon the Son of Man who walked on earth until he was 33. We don't do that whole, that's obviously talking about one specific faith. By referencing God, if you believe in any faith, you have a belief in some God. So they call that a non-denominational prayer. So it's non-denominational, and it's a voluntary prayer. What do you think the Supreme Court says about this? Anybody that's been in a classroom after 1962 can answer this? And I ask all my students, how many of you started your day with a school prayer? And none of them raised their hand. I said, well, you know the outcome of this case, right? Almighty God, we acknowledge our dependence upon Thee. We know where this is going. The Supreme Court is going to say, we think that by using its public school system to encourage recitation of the Regent's Prayer, the state of New York has adopted a practice wholly inconsistent with the Establishment Clause. They're saying, essentially, in this 1962 case, they changed the definition of the First Amendment. The First Amendment talks about the establishment of religion. Now, when we look at that prayer, is it the establishment of religion? If you interpret it to mean establishment means creating the government religion. Are they creating a religion here? No. Are they prohibiting someone's free exercise? It's a voluntary prayer. You could walk out of the room. But we need other words to define what this actually means, because these two don't apply in this particular case. So how is it a violation of the First Amendment? Well, what they do is they actually change the definition of establishment to actually mean also encouragement. So they are not establishing religion, but the Supreme Court is going to make the case that they are encouraging religion. And by encouraging religion, they are essentially promoting the practice of establishing religion. So the Supreme Court is going to say, we think, there can, of course, be no doubt that New York's program of daily classroom invocation of God's blessings, as prescribed in the Regent's Prayer, is a religious activity. This is one of the most controversial cases in the past 50 years. Even today, many people in this country, a majority of people in this country, do believe, I mean, you might not know this here in New York, but many people around the country actually believe that they should start with a prayer. This is one of the most frequently cited cases where people are going to challenge their congressmen and their senators to pass an amendment to actually overturn this. Extremely controversial. By the way, what's going on in 1962? Who's in the White House? John F. Kennedy. And only 2 years before, John F. Kennedy had run on a campaign really to get under this cloud that people believe that he would not listen to the Constitution, but take his orders from the Pope in the Vatican. So this is extremely controversial because John F. Kennedy, the sitting president, running potentially in the next 2 years for re-election, has to now weigh in on this. It's going to be not only controversial in our own classrooms and our schools around our neighborhoods, but in the political climate at the time, it's going to be extremely controversial as well. This case, Marsh v. Chambers, is going to revisit almost the same issue. In Nebraska, Nebraska is one of the only states in the country that has a unicameral legislature, which means they only have one house making their laws in the state of Nebraska. This man, Ernest Chambers, is going to challenge the chaplaincy practice in the state of Nebraska. The chaplaincy practice meant that their legislative session would begin with a prayer. Voluntary, again, non-denominational, similar to the previous case. He's going to sue a man named Marsh, who's the treasurer of the state of Nebraska, because he's the guy whose name is at the bottom of the check to the chaplain saying the prayer. So he's going to sue on the grounds that because the taxpayer dollars are going to this chaplain to say a prayer in a government building, it's a violation of the Establishment Clause. Establishment, as we said in Engel v. Vitale, equals also encouragement. So just the fact that this government institution is encouraging prayer, it's a violation of the Establishment Clause. Anybody know, if we look at Engel v. Vitale as our precedent, who wins this case? Who? Chambers. Chambers is the guy in the state legislature who doesn't want the prayer. He thinks it's a violation of the Establishment Clause. Chambers actually loses this case. Chambers is going to use Engel as the precedent, but the Supreme Court is going to almost completely ignore Engel as precedent in the case. What are they going to go with? They're going to say from the colonial times to the founding of the Republic and ever since, the practice of legislative prayer has coexisted with the principles of disestablishment and religious freedom. They're going to use the idea that there's a tradition that we start the legislative session with prayer. Well, couldn't they say the same thing in Engel versus Vitale? It's tradition that we start our school day with a prayer. They completely ignore that. There's another clause that's a little bit different. They seem almost simultaneous. You have a religious institution, you have a state institution, with a prayer, non-denominational prayer, voluntary starting their day. The difference also in the two cases is the fact that in Engel versus Vitale, look at the audience. The audience is young children it is mandated that they be there. There's no mandatory submission to sitting there for Ernest Chambers. Ernest Chambers, different from the school kids, ran for election, probably ran in a primary. After he ran in a primary, he ran probably in a contested general election, and then he got elected. Then he went there, and said, wow, I jumped through all these hurdles to get here, to say, wow, now that I'm here, and after I jumped through all these hurdles, I'm really uncomfortable. Very, very different from the school kids. In the school kids case, the court is going to make the case that they're mandated to be there. Ernest Chambers is not mandated to be there. On many of the cases involving the Establishment Clause of the First Amendment, what we're going to see is the idea that this idea of tradition is going to be something that is upheld over and over again. The Supreme Court, by the way, anybody know how they start every one of their sessions? The prayer. Oyez, 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 may God save the United States and this honorable court. Reference to God above the Senate.
Excuse me.
Yes, sir.
The Regents one, you said that was started in 1951, the prayer?
Yes, that particular prayer was written in...
Right, but this was saying going back to colonial times.
Right.
So, you know what I'm saying? That case was brought in 62.
Right.
So you talk of 51 to 62. This one's talking from colonial.
Well, in New York, it was written in 1951, but the tradition of school prayer before that had pre-existed in places other than New York.
The point I'm trying to make is that they're two totally different cases. I mean, a tradition isn't 11 years.
Sure.
So.
Well, the tradition is more than that specific prayer. The tradition is starting the day with a prayer. The challenge in that case was that specific school prayer.
Right, okay.
Right? So,
okay, I got
it. People that went to school in 1950 heard a different prayer in different places.
Okay.
It's just that prayer was instituted in 51. And tradition actually is whatever the court says it is. It's not, they say, well, we've been doing this for 3 months. That's our new tradition. The court has a lot of power. And then if we don't like it, vote them out. Oh, no, wait, we can't do that. This other case is going to be another important one, actually the way that we started this session here tonight. The Elk Grove Unified School District versus Newdow. This one you're going to enjoy. Elk Grove School Down. Michael Newdow is an atheist, and he has a daughter in kindergarten in the Elk Grove Unified School District. He's going to sue on her behalf, basically saying that the words under God in the pledge, although they are voluntary, although she is not mandated to say it, although she could sit down during the pledge, she could walk out of the room, just the fact that the other students in the class are saying under God in the Pledge of Allegiance is an undue burden to her. Now, under God is added into the Pledge of Allegiance in the mid-1950s by Congress. It really is added initially as a way to, in one aspect, as a way to kind of combat what they call the godlessness of communism. We're going to even include this in our pledge. But it also obviously has a religious reference as well, and a traditional reference to the traditions of our country being founded on the premise of divine providence and things like that, as we see in documents like the Declaration of Independence and other founding documents. So the Elk Grove Unified School District is going to be sued by Mr. Newdow. Now, anybody know how this case actually winds up? Do we have under God in the pledge in our schools? Are we allowed to say it? Okay, some yes, some no. Newdow lost.
Yeah, we do.
No, they have standing.
What's that?
Newdow didn't have standing.
Didn't have standing, okay? The Supreme Court kind of punts this one. What do they say? They don't answer the question whether under God is actually allowed in the pledge or not. What they actually say is, in our view, it is improper for the federal courts to entertain a claim by a plaintiff whose standing to sue is founded on family law rights that are in dispute. Now, Newdow, while this was his daughter, he was involved in a custody battle over her, and she was actually, her legal rights and her educational future were to be determined by the mother of the child. In the contract between him and his ex-wife or ex-common law wife, he didn't have standing, he didn't have any custody over his daughter in terms of her educational future or the legal disputes that would go on in the future over her. Now, in this particular case, the Supreme Court, instead of saying whether under God is allowed or not, said that you can't sue on her behalf, essentially is what they said. So the question was never answered by the Supreme Court whether or not under God is allowed or not in the pledge. Now, you might think that they did punt it in some ways, like I said, but actually what they did was the correct move. Because if you take a look at it, if Mr. Newdow, if they were able to answer this question, it essentially would have set up a precedent beyond under God and the Pledge of Allegiance. It would have set up the precedent that you could sue on behalf of somebody that you do not have any claim in the case. So I observed someone walking up here trip over the curb, and even though I don't represent you in any way, I say I'm going to sue on your behalf. And I could cite Elk Grove Unified School District versus Newdow, saying I could sue on behalf of somebody that I have no legal standing to sue on their behalf. So there are some side issues involved in these things as well. So essentially, what we're talking about here now in my class, when we talk about freedom of religion, we spend like a couple weeks on this. So I kind of just tried to race through it a little bit so that I wouldn't put the entire room to sleep entirely. But essentially, what we're looking at here is the idea of religion in the Constitution. One thing that we see about the idea of religion is that we have become more and more tolerant over time of other faiths. You look at the year 1960, John F. Kennedy is elected Roman Catholic, first Roman Catholic president. Only 40 years before that, Al Smith, many people actually say that that was one of the reasons why he did not get elected. In the year 2000, Al Gore and his running mate, partly on the strength of his running mate, I'd say mostly on the strength of his running mate, Joe Lieberman, receives more votes in the presidential election than George W. Bush. Joe Lieberman is the first candidate for national office to be of the Jewish faith. In 2001, in the aftermath of the 9/11 attacks, we not only do not see widespread condemnation of the entire Muslim faith, George W. Bush, one of the first moves that he does in the aftermath of that, I believe the day after, is to visit a mosque and put his arms around the imam. So we do see a toleration in this country that you do not see in many other places. We do not see the religious wars that have existed in many other places. Where do we resolve most of our disputes or issues over religion? We tend to go to the courts. And after the courts weigh in, even though Engel versus Vitale, school prayer is extremely contested even today, and many people have a big problem with that decision, we're not fighting in the streets over it. So the idea of toleration and religion and the Constitution, you know, the founders obviously have laid the groundwork for issues that are still being debated. You know, we talked about 10 cases that have taken place from 1879 all the way up until, you know, was it 2005? And most of the cases, and the cases that we're talking about, are over 16 words in the Constitution. So it's pretty interesting that some of these things we are still debating. We will still be debating them, and many of them are still unresolved, but some of them have been resolved.
There was one other case that you might give some consideration to. The one about the Bible, wasn't that stricken from the schools?
Yes, that was the Shemp versus the Abington School District. The same way that they held in the Engel versus Vitale case. It was almost the same case, but the issue was Bible recitation in class, and the teacher could actually select the passage. It was almost the same outcome, same idea that the teacher is encouraging religion, the teacher is an institution of the state or a representative of the state. There are a lot of cases that we could have put in here. I did not even scratch the surface of religion in the Constitution. The idea of a prayer during a school event, during graduation, the fact a nativity scene in town hall, whether or not these things are constitutional. In no way would I ever come in here. I'm still learning about the Constitution myself. I like finding groups of people that like talking about the Constitution. Like I had said before, if I said we're going to talk about religion and the Constitution, if I came up in here and surprised any other group somewhere on Long Island, the room would be probably cleared out. But it's nice to be able to come out and spend a little bit of time talking to people that are interested in these things and have some involvement in it. We didn't even scratch the surface. even though the idea of religion in the Constitution, really many of all the way up until Cantwell in 1940, there's only 5 cases involving religion in the Constitution in the Supreme Court. After the 1940s, that's when we see most of the cases, predominantly many of the cases, are going to come out of that, after the aftermath of that Cantwell case. What we're also going to see is many of them is going to be over that establishment idea. Where is that line? You know, a couple of words that we never saw in the Constitution. There's a reason why I went through the Constitution. Many of my students immediately put up their hand and say, well, what about the wall of separation? In those words. Remember Christine O'Donnell when she said in the campaign note, the separation of church-state isn't in the Constitution. You remember what the crowd did?
They laughed.
They laughed. And anybody see what was on the sign behind her? She was in a law school. These were first-year law students. Okay, I didn't go to law school. I did most of my graduate studies involving the U.S. Constitution, and I'm just interested in the subject. First-year law students laughed at the idea that separation of church and state is not in the Constitution. Did anybody see those words at all? No, it's an interpretation by the Supreme Court. Sir?
On the Cleveland case, where the voucher system won,
Right.
recently, or since Obama's elected, they pulled the voucher system in Washington, D.C. Has
Okay.
anybody contested that, or?
Well, it's up to the state or the school district or the locality to determine whether or not they're going to institute it. That is not a forced program. It's simply a program that is instituted by Cleveland, and then it's going to be contested in the court. It doesn't mean that every district has to adopt that system. So I'm not sure.
And parents were very unhappy when it was pulled.
Right.
Something like 1,500 children were forced into a failing public school system. So I was just wondering if any of them.
They may challenge it in terms of getting it initiated or addressing that to their members of their city council, but the court issue of whether they are obligated, the city or state or school district, to give the funding, that hasn't really been addressed at the Supreme Court level. And I haven't heard anybody trying to take that up at the Supreme Court level.
Being that the Constitution is outdated, so they're saying, do you foresee any changes with taking God out of it?
Well,
You know, because they're saying it's outdated, they want to revise it, which I don't believe.
Right.
Do you see that in the future, some people in our leaders would take this out?
Take under God out? Well, they would. The Supreme Court could essentially rule that under God has to be stricken from the pledge. That could be done.
Not the pledge, the Constitution.
You got through legislation, right?
Well, to amend the Constitution, you have to go. It could be done. Yeah, you can go through the amendment process of Article 5. Essentially, you have to go through both houses of Congress. You have to go through 3/4 of the states. You could pass an amendment, essentially transforming the words of the Constitution. Absolutely, it could be done, but it would take more than just presidential action or congressional action. You would have to a large number of states. That's why it's so infrequent that the Constitution has been changed.
I think the real issue is not so much what's in the Constitution, is who's sitting on the bench, who's deciding what is and what's not there. The real problem is in holding a separation of church and state. Not only was that not in the Constitution, but that was a letter from Thomas Jefferson that was quoted by Hugo Black, who was a former member of the Ku Klux Klan, a very anti-Catholic a member of the court. So the whole issue really is personalities that's on the bench. 9 individuals who were elected and accountable to no one, who have a life tenure.
That's right.
And once they're on there, once they go through their sort of kabuki dance of confirmation,
You're
as
absolutely
Megan
right.
Payne said.
No, you couldn't be more right. I talk to people about electing the president, and I say to them, what's your issue? They're like, I just like this guy. I just like that guy. He's going to be gone. And I don't just mean Barack Obama. I mean any of them. In 2012, the Republican is going to go in. They'll only be there 4 or 8 years. The person that they appoint to the Supreme Court is going to be there when your sons' sons' sons are born. well, your children's children born. We have John Roberts, Sam Alito, are appointed not just because of their brilliant minds, or not just because of their political beliefs or their belief in the law, but how old they are. The fact that both these men were in their mid-50s or younger, they potentially could be there for the next 30 years. And it is important when we look at electing a president to look beyond their policies, but look to what their agenda is with the court. Now, this is one of the most dangerous things. You ask the average American about the Supreme Court, and they don't know anything. They know beyond nothing about the Supreme Court. In one CNN poll, they asked a group of people to name a Supreme Court case that was decided that was decided by the court. They couldn't name any. Couldn't name one. Marbury versus Madison, Roe v. Wade, Miranda versus Arizona. They couldn't name any of these cases. This is a problem. Most people don't know how many justices are on the Supreme Court. Most people don't know the tenure of the Supreme Court. Most people don't know the idea that a name of a person on the Supreme Court. These people are more powerful than the President of the United States. They're unelected, they're unaccountable, they're there for life, and there's no accountability to us once they go through the kabuki dance of the nomination process. Barack Obama's been in office for 2 years. He's already put 2 people on the court. You know, we'll see how that looks going forward. If you like the appointments that he made, he's your guy. If you don't like the appointments that he made, we need to consider that in 2012. And I'm not here to give a campaign speech, but I mean, that's one of the main reasons why we elect the President of the United States, and that is to put justices on the court. And you hit the nail right on the head. They are going to interpret these words, and it's what we look at how they interpret these things. You know, if you believe that a child in a failing school district should stay another year because maybe the school will figure things out, then put the political philosophy of the 4 people that voted against Zelman versus Simmons Harris on the board. Put more of those people on the board. If you think that your child shouldn't have to sit through a school year hoping that things will get better, then put the 5 majority on, and people that believe in that philosophy. And you know, you're 100% right. The court is so important to us, and what they do really defines the law. We saw that in any one of these issues, not just religion. The war on terror. There have been 5 cases that have come up before the Supreme Court involving the war on terror. You know who won every single one of them? I'll give you a hint. Not George Bush. If you like that, if you like the way that George W. Bush was trying to govern during the war on terror during his campaign, then those are the justices that you're going to put on. I think we need to consider the court more than we do.
On England versus Vitale, the son of Madeline Mary O'Hare was in New York in 1990, visiting various churches because he became a pastor. He's now Christian.
Okay.
So he's the one that was involved in the case.
Yeah, New Hyde Park School District it actually was. Just talking about Engel versus Vitale.
Yeah.
Okay.
Anyway, in speaking, he was on a radio talk show in WOCA, talking about how back in the 1920s, his mother and all her group were all involved in communist cell groups, and that they talked about how Supreme Court justices were being groomed for the Supreme Court for the purpose of taking prayer out of schools. And that when it came to 1960 or 58, whenever they brought the lawsuit, they were already prepared. They were asking for cases. They were in the Supreme Court waiting for it. They wanted it to happen. And I personally believe that the regents in the state of New York deliberately created the prayer so that they could bring the case.
It's possible. I mean, there are a lot of cases. She's saying that essentially Engel versus Vitale was a case, it was like a setup case to kind of get prayer thrown out. There were actually 26, a majority of states filed briefs with New York supporting the school prayer. So this is a completely counter to public opinion, as I said before, the outcome in this case. But it's not unheard of that test cases go up. Griswold versus Connecticut, one of those important cases of the 20th century involving the right of a married couple to talk with their doctor or someone in prescribing birth control, which has essentially created the right to privacy, which essentially is the precursor to Roe v. Wade, to test case. How does the police department know that a doctor is in a doctor's office prescribing this medicine? Well, it's a test case. Planned Parenthood of Connecticut called up and said, at this time tomorrow, we're going to prescribe this drug. Brown versus Board of Education is a test case. It is a case that there was a legal strategy from the NAACP, and I'm not saying that this is wrong. You know, we just have to, in the case of Griswold versus Connecticut, you know, this is part of the history of these cases, though, that there is a legal strategy. Many of the death penalty cases are a legal strategy. The abortion rights cases, it's a legal strategy of the right to life movement, and there's nothing wrong with that. But it is part of the history of these cases.
I'm sorry to talk about legal strategy, but it's also a legal agenda on the part of the court. In Griswold versus Connecticut, William O. Douglas said there's a right to privacy emanating from penumbras within the Constitution. Which
yeah, the right to privacy is another like 2.5-hour lecture. That is right. Essentially, here in all these, we can at least point to clauses in the Constitution. Well, when we talk about Griswold versus Connecticut, they make it all.
Well, it's a handcrafted right, and that laid the basis for abortion 8 years later with Harry Blackman.
Why don't we, if anybody has one more, we could take it in the back, sir. Right.
That's not anything in the Constitution, right? Not in the church, but it became tradition. Is that what happened?
Well, it became tradition until Reynolds versus United States, which he said, hey, legitimate, that clause about legislative action cannot touch opinion, but it can touch action. That's right out of that letter. On the back of the card that we gave out, that's right out of Thomas Jefferson's letter. Also, the wall of separation, we do see that, as someone had pointed out also in the Everson case. He says there is a wall of separation, and once the Supreme Court, in their opinion, says there is a wall of separation, they are charged with interpreting the Constitution. Their interpretation of the Constitution is the Constitution until they interpret it different, or until a constitutional amendment says something different. So essentially, because of their unique role, that their unique role of interpreting the Constitution, which, by the way, they gave to themselves as well in Marbury versus Madison, that's not in the Constitution either, that the Supreme Court is the final interpreter of the Constitution. That's nowhere in there. They found that in Marbury versus Madison. We're going to be the ones that decide what the law is. But essentially, once the